Florida DUI law has a no-tolerance policy for individuals under the age of 21 who drive while under the influence of alcohol. The legal blood alcohol content limit for drivers under 21 is only 0.02%. This limit is substantially more stringent than it is for drivers over the age of 21. The legal blood alcohol content limit for drivers over 21 is 0.08%, which is 4 times the limit for drivers under 21. If you or your child is under 21 and has been arrested for DUI, you should contact a DUI lawyer right away. The penalties for a driver under 21 operating a vehicle with a blood alcohol content above 0.02% or higher can include suspension, probation, fines, court costs, community service, incarceration, and increased insurance premiums. If the driver's blood alcohol content was between 0.02% and 0.08%, the driver will likely not face criminal DUI charges. However, the Florida Department of Highway Safety and Motor Vehicles will automatically suspend the driver's license. If it is the driver's first DUI offense, the license suspension will remain in effect for 6 months. If the driver has prior DUI offenses, the license will be suspended for 1 year. The driver must petition the Department of Highway Safety and Motor Vehicles for a hearing within 10 days. If the hearing is not requested within 10 days of the arrest, the opportunity to contest the suspension will be forfeited. Therefore, it is important to contact a DUI attorney immediately after being arrested for DUI. At the Department of Highway Safety and Motor Vehicle hearing, the hearing officer will review the public record, alcohol chemical test, and other relevant evidence to determine whether or not the license suspension should be upheld. It is important to have an attorney with you at the hearing to challenge the evidence against you and to put forth any evidence that may be used in your favor. An experienced DUI attorney may be able to identify grounds for getting evidence against you thrown out of the hearing. For instance, evidence may be excluded from the hearing if the initial stop was unconstitutional or if the chemical blood alcohol tests were not administered properly. Furthermore, an attorney can present evidence in your favor and cross-examine witnesses to persuade the hearing officer against upholding the suspension. If the driver's blood alcohol content was 0.08% or higher, the driver will face criminal DUI charges. The procedure and penalties will be the same as it is for drivers over the age of 21 who are arrested for DUI. However, drivers under 21 may face additional penalties that are not applicable to drivers over the age of 21. For instance, a DUI conviction can drastically hinder the driver's ability to get into college or find a job. At Florida Law Advisors, our DUI attorneys are experienced and skilled in all aspects of a DUI case. We understand how important the outcome of a DUI case is and work diligently to help protect our clients. We aggressively defend our clients in all DUI matters and work tirelessly to achieve the outcome our clients need. Regardless of the circumstances of your case, we may be able to help. For more information, contact us today to speak with an attorney at our firm.